Hello, hello, hello. This is Attorney Mike Grevlin coming to you from Chicago as usual. And I'm doing an old-fashioned intro here because this case is weird. This case is weird, and I'm going to give a little overview because some people don't know what's going on. Sharrone Moore was the football coach for the University of Michigan for a brief period of time. But that's a hell of a good job. That's a top program, and that's a very well-paid position. I don't know how I missed this, but I have to shout out to Jammin, who put it in my Discord for me. It was yesterday, apparently. Anyway, I happen to go to the University of Michigan. I grew up in the state of Michigan. I always liked Michigan football. I was at the national championship game when they beat Washington a couple of years ago at NRG Field in Houston. There. So I'm a Michigan fan. But that's not why I'm doing this. The weird cross-section for me is I also started this YouTube channel. And one of the first judges I started covering, I think before anybody else, I challenge anybody to find an earlier video than I have on my channel of Judge Simpson. And through a very, very weird set of circumstances, Sharrone Moore, the head coach of the University of Michigan football team, ends up appearing in front of Judge Simpson. It's blowing my little mind. Anyway, the general allegations are he was involved in an affair, and he was doing I don't know. They get into Title IX, whatever. I don't know. He got caught in an affair, which is not the end of the world in and of itself, but then he didn't handle it well. He did not handle it well. So Sharrone Moore was an assistant coach under Jim Harbaugh when they won the national championship a couple of years ago. Although there's a bunch of people whining and complaining, mostly because Michigan was whooping their ass, that Michigan was cheating. So Jim Harbaugh had to sit out a few games, and Sharrone Moore stepped in and did a decent job. So when Jim Harbaugh went off to the NFL, they elevated Sharrone Moore to the head football coach position, which frankly was a bad hire. He's a good coach, not a great coach. He isn't good enough to take on that position, to be blunt. He doesn't suck. He's okay. He probably should have started somewhere lower than that, to be blunt. But that's neither here nor there. That's neither here nor there. He did okay in his short tenure. Not great, not horrible. But he gets busted. And as his world's unraveling, because whoever this woman he's having an affair with, who's his assistant, allegedly, and by allegedly, it really looks like that's what was happening. Apparently, he gets into his feels like no man should. And he starts running around, thank you. And he starts running around making threats to her and to himself. I feel sorry for him. It's tragic, but you can't do that. You can't do that. Anyway, he gets arraigned a while back. He ends up in front of Judge Simpson, I guess yesterday is my guess. I don't know. I missed it somehow. And here's that appearance. But that's just sort of what we're dealing with. And here he is. This is just weird to me. But here he is appearing in front of Judge Simpson.
Why? They're on their way. They coming down this way or that way? Court does call the case of the People's State of Michigan versus Sharrone Moore. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Rismersky for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sharrone Moore, who is present in court.
Your name, sir?
Sharrone Moore.
All right, thank you. Can you grab my file back? All right. Your time set for a probable cause conference. What do we need to do today?
I've had the opportunity to talk with the prosecutor. There is outstanding discovery that we need to have before we can proceed to exam. So we're asking to adjourn the probable cause conference for 30 days to receive that discovery. And the discovery, we're talking about our phone records and Title IX documents.
Okay. Are the people going to be in possession of Title IX documents or have access to those? I guess.
It's a very good question, Your Honor.
Thank
My best understanding.
I usually ask good ones, but
You do.
go ahead.
This court always does. My best understanding in the moment is that this is not a Title IX investigation per se. My information is coming in real time, as they also say. It was a complaint apparently to the Office of the General Counsel. I have just moments before we came onto the record been informed that there is no written report. That is my best understanding. Whether or not there is some other kind of.
All right, for those of you who don't know, the law that Title IX is the law that prohibits sex-based discrimination, including sexual harassment and sexual assault, and education programs that receive federal financial assistance.
Investigated information that exists has yet to be ferreted out. That effort, that process is ongoing. Ms. Michaels is correct in the aspect of phone records are being sought. All of the, just so the record is clear.
Although I don't think those are that's not the basis for the charges here. I think he was charged with, I don't know what, I can't remember. I have his arraignment. Probably assault. I don't know. I have his arraignment. You know what? I just made a playlist, so I'll look back at it. But it was because he was making threats to himself and her. You know, it's probably some, I don't know, disorderly conduct and assault or something like that is my guess.
All of the evidence and discovery that we have has been furnished to defense, but the investigation is ongoing.
Okay.
Whether or not 30 days is sufficient is a live and good question.
Okay. Well, and let me just make sure that I'm clear. Whether 30 days would be sufficient for phone records is questionable, or for everything that Ms. Michaels indicated, I guess.
I believe my thought was everything, but I think that also applies to the phone records. Quite frankly, Judge, I don't know what that timeline is. I can try to find that timeline out and communicate that to the court and counsel, but I don't have that.
Okay, and I guess I'm not.
Disorderly caulking. You know, I am something of an expert on the topic. I'm just saying.
What I don't want to get to, I guess, is a point where we're at a certain point, it may be ready to be set for exam or do whatever, and everything that these records, I'm presuming, Ms. Michaels, that you're saying from the U of M, that are records from the U of M.
Correct. It's our understanding that when you just step back a touch from the actual incident, there were statements made and things done earlier that day to the U of M, statements made by the complaining witness that are going to be important to this investigation because her credibility will always be at issue, and different statements she made to different people will need to be evaluated. So those statements are important.
Okay, I get that, but those, I mean, aren't those documents or statements that you can get on your own, or?
That's a great question. I can issue a subpoena if the court is willing to sign a subpoena. I will send a subpoena myself, but I do know based on the police reports that the prosecutor's office is also seeking those documents. And in my experience, documents, people are much more ready to turn over documents to a prosecutor's office than to a defense attorney.
Guess
We may
that's,
quibble about that, but
yeah,
I
so
don't,
it depends.
Yeah, she's right. She's absolutely right. And it makes all the sense in the world. It doesn't matter. This is a minor point, but yes. Yes, people get freaked out when they get a subpoena from the prosecutor's office, but from a defense attorney, meh, whatever.
On one's view of life.
but I take no issue with just flowing it through us.
Yeah, right. I don't have a problem with that either. It's just, I'm trying to figure out if the request is made. So, because are you attempting to try to obtain those documents?
I am.
Okay. And then once you obtain them, if you do obtain them, you're going to inform counsel or provide them to counsel.
Immediately.
Gotcha.
One more thing, Your Honor, for due diligence sake, maybe I should submit to the court a subpoena for signature, and of course I'll serve the prosecutor, and I can also submit a subpoena requesting those records, having them returned to the court.
Well, having...
She's excellent. She's an excellent attorney. That's exactly what you do. If we're going to have this whole go around, let's make a record of it right here that I will do everything so that the delay is not on me. Of course, it makes sense. Despite the fact that this guy lost millions of dollars by playing hanky-panky here, he still has enough money to hire a very good attorney, which makes sense.
The results come to the court.
Correct.
Okay, and then we would... Okay, I don't have a problem with that if we're the go-between that it comes here and then goes out. I don't necessarily have that. So unless there's some legal objection to it, if you submit a subpoena to the court, I would sign off on it. I guess try to get this so we can get this thing moving.
Yes. Yeah, I never mentioned this on their air because why, or whatever, on my show, why would I? But you know how I feel about men crying in public, and he would get emotional after Michigan would win. And I'm thinking, this guy, like, and I'm pulling for him, but I'm like, this is not going to end well. And it didn't.
30 days. So there's also, and just so that's the discovery issue. Today, I guess that was filed a motion to quash.
That's correct. Earlier today, I, at the court window, filed a motion to quash the arrest warrant and a request for a Frank's hearing. I have a signed copy to tender to the prosecutor, and we will be asking for a hearing date on that motion.
Okay, do you want two separate dates? I mean, how fast do you want? Well, first of all, I mean, the people have to answer. So
Sure.
I guess how fast do you want this?
This can,
And what I'm indicating to you, Ms. Michaels, is I can set the motion along with the PCC, hear it all at that time. Or I can give you a date for this separate and apart from the PCC.
I would like a date separate and apart. This motion is not determinative of those records. It is prior to those records. So a date to hear this motion prior to receiving those records would be our request.
Right, but I mean, presumably, actually, you're then talking about 3 hearings because there's going to have to be a hearing on the motion to determine whether or not you'd be entitled.
Yes, and I tip my cap to Indiana. Nice job. Congratulations on the national championship. I thought it was beautiful, but no, he shouldn't be crying after the national championship game. No, he shouldn't. It's not good. Show me a guy who cries in public or thinks tooken is a word, and I show you a future arrest. Plain and simple.
To a hearing, an evidentiary hearing. Then, if necessary, I'd have to set the evidentiary hearing. And then we would also have the PCC.
That is accurate. So a suggestion may be to, whatever the court desires.
Oh, you don't want that. No, go ahead. Okay, that's fine.
You know, this is a lot. So in the expedience, we'll leave it to the court's discretion as to how you want to set things.
That part of it, but we'll try to get through it as quickly and as expeditiously as possible. But the people have seen the motion. How long are you going to need to respond to the motion for the first part of that?
So although I was aware that a motion was filed this morning, I was not served with a copy until moments ago. I have obtained a copy through the court file prior to the
Don't even start with me.
this moment and have had an opportunity to begin to flip through it. I have not consumed it in its entirety. How long to respond was the court's question?
Yes. For the first part of a determination as to whether or not there would even need to be an evidentiary hearing in this case.
Court's pleasure, but at least a week.
At least a week.
Oh, I'm missing Auckland right about now.
Okay. And
Would you like me to look?
well, I even have to set it on an off day.
Yeah, I was thinking like a Monday or Tuesday.
Monday morning.
Yeah. So just tell me how far.
If I give it 10 days. A second, I'm just going to do our race continues on 10 days. And just give me a week to go through everything. So around this time. Yeah.
It's Jerusalem. I think somebody wants
Seriously.
I think so. We can just move the date.
Got it.
Yeah, Monday.
Okay. Will that work?
Let me make sure. Yes, that will.
All right. So with reference to the motion, I'll have the prosecutor's response will be due by maybe longer than a week, February 2nd.
Thank you.
February 2nd, 2026. I will then set this for hearing on the motion for February 9th.
I was going to, but I had court all week. I'm not happy about it. I got stuck in the polar vortex.
Let's get 1 p.m.
2026,
Yeah.
at 1 p.m.
Your Honor, may I speak out?
Yes, go ahead.
In the moment, I have a murder case set to start on that date. That may
That's
change, even within the end of the day today, that may get moved. But in the moment, that is day one of a murder.
that's day one.
That's not a good date for me either, Judge.
You give me a date. Let's see what we can figure out.
Tuesday.
Well, Tuesday the 10th is not going to work if the murder trial goes. So
Tuesday the 17th at 2 o'clock.
Should be fine.
That works for me.
at what time?
2 p.m.
All right. So the motion will be set for February 17, 2026. You said 2
Yes, sir.
at 2 p.m. Okay, and that will be an in-person hearing. We then, in understanding that, depending on the result of that motion, there may be another date that is set. But I'm not going to deal with that at this point because a determination has to be made. So I'll adjourn the probable cause conference. Normally, I'm not really going to care about the date itself, but with all some of the logistics that come along with this case, I have to because of other docketing concerns. Will March 19th then work? I realize that's a little bit longer than what you asked for, but we're going to see each other on the 17th. And then I would adjourn this out to the 19th, hoping that all discovery, at least at that point, is clear.
That works for the defense.
Works for me as well. Thank you.
All right. So probable cause conference will be adjourned to March 19th, 2026, 9 a.m. or as your invite indicates. Is there anything else from either side?
Nothing for the
No, Your Honor.
All right.
Thank
Thank
you
you
very
very much. Bond will continue.
Thank you.
Thank you.
I'll let this run just so you can see the crowd that shuffles out. That's a big crowd for a little court hearing in A squared. Trust me. Trust me. Yeah, that's how cold it is here. This is how cold it is. My heat is on and everything's fine. But I'm rolling around my condo with this hat on, making coffee. That's what I'm dealing with, people. Screw this. I'm going back to New Zealand. It was very nice when I was there. Or Australia or Honolulu. Any of those will work. They're all fine. And they're beyond fine. All three of those are beautiful. But no, here I sit in Chicago. But when I'm back in Chicago, I feel it. All right, so I'm going to follow this case. I appreciate that some people don't care about it's weird. Like I mean, the fact that it's football is just that it's football. It's just that it's just that he's famous and he's in front of Judge Simpson. That's just so wild to me. Like when I started this here channel and I'm like, oh, this judge is interesting. Nobody's watching, and I'm just like, oh, this will be fun. I'll just do this, and then Judge Simpson becomes famous, and then he ends up with a. You don't usually get a D1 coach in court on a criminal charge. Those are middle-aged dudes with a pile of cash. I'm not saying they don't do stuff wrong. I know some middle-aged dudes with piles of cash that do things wrong. They're just usually pretty damn good about not getting caught at that point. That's why it's a rare occurrence. You know what I'm saying? Oh, good Lord. There we go. So I'm going to follow this. I doubt we go to hearing. He would be insane to take this thing to hearing. Just take your, oh God, if he would have just shut up and taken his L when all this went down, first of all, he might have survived it. Probably not. If he would, I'm telling you right now, I'll tell you how much people don't care. Are you the one who sent it to me? Thank you. I'll tell you how much this doesn't matter. I think he got fired for being mediocre more than this scandal. I think this scandal was a convenient off-ramp for the University of Michigan to get a better coach. I'm being blunt. And I don't think he's terrible. I think he's okay. I think he could have had a good career, but he was like an assistant coach, and then he's got like one of the top jobs in the entire sport. No. He was not there yet. If they had, say, beaten Ohio State this year, they probably would have swept this under the rug. That's how, like, if he would have not gone and had a freak out and allegedly had a felony home invasion involved here, he would be negotiating with them, with his attorneys, to pay out, because he'd say, oh, there's some, you fired me, you didn't have a proper basis. That's the litigation we'd be having. University of Michigan would be going, oh, okay, we'll pay you half your contract to shut up and leave. That's how that, and we're talking about tens of millions of dollars here difference. That's how much it cost him to get in his feels and run over there. Those are the facts. That's the straight truth of the situation. I'm very close on both ends of this. I'm more familiar with the University of Michigan football and Judge Simpson than 99% of the people on the planet, and certainly where it collides, even more so. I don't know. I don't know what good that does you, but it is true. All right. Thank y'all for coming out. I'll follow this. The preliminary hearing should be pretty damn good if we go through that. That I think is the only hearing we get. He would be insane to let this thing go to hearing. He probably did it. I don't know. Thank you so much. I don't know why nobody else told me this. I wanted to follow this case. I feel bad that I'm a day late on it, but you know, better late than never. That's my theme. Anyway, I think I'll follow this case. Sometimes I just have to follow something. Sometimes that's Clay Township board meetings. At least this has some star appeal to it. It's got more star appeal than Clay Township. I mean, all we have is this. Oh, well. All right. Thank y'all for coming out. I appreciate it. Let me go find some fun stuff for a happy hour. Let's forget this ever happened.